The discovery process. The process of obtaining the facts and evidence to be presented at the time of trial is known as the discovery process. The parties exchange information and learn about the strengths and weaknesses of the case. Anything that is relevant to the claims or defenses is discoverable, even if certain information or documents would not be admissible at trial. It may still be obtained if reasonably calculated to lead to the discovery of admissible evidence. Discovery must be completed 30 days before trial or 15 days before arbitration. The purpose of discovery is to guarantee a fair trial and to prevent surprises from occurring at trial. Rule 26 of the Federal Rules of Civil Procedure. Pursuant to Rule 26, the information about witnesses, relevant documents, plaintiff's calculation of damages, and defendant's insurance coverage are core initial discovery. Such information must be automatically provided at the outset of the federal lawsuit. The deposition. A deposition is an out-of-court statement given under penalty of perjury by any person who is involved in the case, such as parties or witnesses. Both parties have the right to be present during the taking of an oral deposition. Depositions allow the parties to know what a witness will testify to during trial. Witnesses who are unavailable to appear in person during the trial can have their deposition testimony read into evidence during trial. In addition, deposition testimony can be used to impeach the credibility of a witness who testifies during trial if what the witness says is different. The cross-examining attorney can ask the witness at trial whether the witness is lying now or if the witness was lying during the deposition. Usually depositions involve an oral examination and then a cross-examination by the opposing side. The subpoena. After the complaint is filed, the attorney may obtain the testimony of any witness by serving a subpoena, compelling the witness to appear at a deposition or to appear in person at trial. A subpoena is a written order issued by the court. Only an officer of the court, such as a licensed attorney or the court clerk, may issue and serve a subpoena. A witness is entitled to fees for their time testifying in court. Furthermore, in order to obtain documents or other tangible evidence from a non-party witness, a subpoena duces tecum must be served on the witness. Failure to comply with a subpoena is punishable by contempt of court and a bench warrant may be issued. Discovery devices. 10 days after the complaint is served, discovery devices may be served on the opposing party. Devices used to conduct discovery include requests for admissions, requests to produce documents and other tangible things, and interrogatories, which are written questions required to be answered in writing under oath. If a party fails to comply with discovery requests, a motion to compel the party's responses may be filed with the court in which a court order compelling the party's responses may be granted. California Rule of 35. California Superior Court follows the Rule of 35. The parties are limited to propounding no more than 35 special interrogatories or requests for admissions with possible supplementation of earlier answers before trial. The California Judicial Council has designed a form document known as form interrogatories, which include the common questions asked in certain cases. Form interrogatories do not count against the Rule of 35. In California limited civil cases, the parties are limited to only 35 total discovery requests for all forms of discovery, including only one deposition for each party. Discovery in federal court. In federal court, there is a limit of only 10 depositions and 25 interrogatories for each party. But there is no limit on the number of requests for admissions and requests for production of documents. In addition, when the opposing party fails to timely respond to requests for admissions, the propounding party in state court has the burden to file a motion to have the request deemed admitted. Whereas in federal court, pursuant to Federal Rule of Civil Procedure 36B, the requests are deemed admitted automatically, and the party who failed to respond to the request for admission has the burden to file a motion to vacate. Moreover, in federal court, there is an obligation to automatically supplement and update responses as new information is available. Whereas in California state lawsuits, a request to supplement must be propounded on the responding party. California expert discovery. Approximately 90 days before the trial date, the parties participate in pre-trial settlement conferences with the judge. During this time, expert witnesses must be disclosed. After a trial date is set, any party may serve a demand for the simultaneous exchange of information about the expert witnesses who may testify at trial. California Code of Civil Procedure, Section 2034.210b, defines experts as parties, employees of a party, or witnesses who have been retained to express an opinion as part of the litigation. A party may also demand the production of all discoverable reports and writings used in preparing the expert's opinion. Pursuant to the California Code of Civil Procedure 2034.220, the demand must be served no later than the 10th day after the initial trial date is set, or 70 days before the trial date, whichever is closer to the trial date. The lists of expert information must be exchanged 50 days before the trial date, or 20 days after service of the demand, whichever is closer to the trial date. If any of the experts is a party, employee of a party, or expert retained for the purpose of providing an expert opinion at trial, the exchange of information must also include an expert witness declaration. A retained expert is a witness who was hired for the purpose of forming and expressing an opinion in anticipation of the litigation or for preparation for trial. Whereas a non-retained expert is one who was hired for another purpose rather than for litigation. The expert witness declaration is signed by the attorney or self-represented party and provides information about the expert's qualifications, a brief description of the general substance of the expert's anticipated testimony, the expert's fees, and that the expert has agreed to testify at trial and is sufficiently familiar with the case to provide meaningful testimony. The court will exclude the evidence provided by the expert if the party does not respond to the demand, provide an expert witness declaration, produce expert reports, or submit to an expert deposition. Pursuant to People v. Kelly and Fry v. the United States, California Superior Courts admit expert testimony based on novel scientific evidence only if the methodology applied is generally accepted in the relevant scientific community. The demand for production of information about expert witnesses allows the opportunity to research the expert, notice a deposition of the expert, and gather information and evidence in the specialized field to cross-examine the expert. Federal expert discovery. Pursuant to Dauber v. Merrill Dow Pharmaceuticals and Rule 702 of the Federal Rules of Evidence, before an expert can testify in federal court about any scientific, technical, or other specialized knowledge, the federal district court judge must be satisfied that the testimony is based upon sufficient facts or data, the testimony is the product of reliable principles and methods, and the witness has applied the principles and methods reliably to the facts of the case. Pursuant to Rule 26 of the Federal Rules of Civil Procedure, an expert report disclosing the expert's proposed opinion testimony must be produced through discovery and include a complete statement of all opinions to be expressed and the basis or reasons therefore, and the data or other information considered by the witness informing the opinions. The Rule 26 expert report must contain more than conclusory assertions about ultimate issues. The expert report must set forth the facts that outline a line of reasoning arising from a logical foundation. The expert report must disclose the data and other information considered by the expert informing their opinion and any exhibits or charts that summarize or support the expert's opinions. The time for an exchange of the expert reports is generally set by the court in a scheduling order during a pretrial conference. Pretrial conferences. The court may schedule a case management conference once all initial pleadings have been filed. The court will establish the time frame for concluding all pretrial activities and may set a tentative date for trial. The final status conference is the last hearing before trial. At this time, the court will determine if the parties are ready to proceed to trial. Joint trial documents, such as witness lists, exhibit lists, statement of the case, trial briefs, and jury instructions may be required to be submitted at the final status conference.